Testing 1, 2, 3. Testing 1, 2, 3.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session. All persons having business before the court are admonished to draw near and give their attention, for the court is now sitting. God save Texas and this honorable court.
Please be seated.
It's hot in here.
What's that?
It's hot in here.
Glasses. Good morning, everyone. We'll now call our second case for oral submission today, the state of Texas versus Grady Barber. This case is coming to us on an appeal from a suppression question. We have an intoxication manslaughter case, if I remember the facts correctly. The trial court granted a motion to suppress the introduction of evidence resulting from a blood draw that would tend to show the intoxication of the operator of the motor vehicle. There's a statutory provision at play here about that affects the authority of the officer executing the warrant to have executed in the county in which he did. The Court of Appeals for the 8th District, but 9th, Beaumont. We have 15 of them now. Reversed, and we have granted the petition, and we are now going to hear oral argument. With that, I will now call counsel. We'll hear first from counsel for the appellee, Mr. Bennett. Please proceed.
Good morning, and may it please the court. My name is Mark Bennett, and along with Logan Pickett, I represent Grady Barber, who was the appellee in this case and the petitioner in this court. The question on which the court granted review was, is an officer authorized to make an arrest for an alleged offense as within his presence or view when he has probable cause to arrest due to his post-incident investigation, even though the alleged offense occurred neither in his actual presence nor in his actual view? I read it from the card because the literal words matter, and the literal words presence or view means actual presence or view. The question answers itself. In our brief, we've gone back to 300 years of common law to show that the way that the question answers itself, the presence or view means actual presence or view, follows Texas law for, well, and the common law for at least 290 years. Our research sort of.
But
petered
doesn't
out.
your common law perhaps prove too much? I mean, the rationale of the common law rule that you cite us to, and it's very helpful analysis. I appreciate it very much. But the idea was that we wanted the constable to approach a magistrate before effecting an arrest. And here we had the magistrate in Liberty County issuing the warrant for the blood draw, but it was executed in a neighboring county. So the legislature has embraced in the arrest statute, the common law, and then we have a separate statute for obtaining the blood that says that the officer may execute the warrant subject to the same provision that would affect the arrest.
Probable cause to draw blood is not the same as probable cause to arrest, just as probable cause to search a vehicle when a dog sniffs and alerts on the vehicle is not the same thing as probable cause to arrest the driver of the vehicle. The legislature has defined in Chapter 14 of the Code of Criminal Procedure when an officer is authorized to make an arrest. And the case on which the Court of Appeals relies, which is Woodard.
Do we have to overrule Woodard to go with you?
In my brief, I called Woodard dicta. I think I was.
Question was.
I think I was
to adopt
probably.
your position, does this court have to overrule Woodard?
I think I was probably being charitable in
Yes, you were.
Woodard. This court could call Woodard dicta. I don't think that's quite right. I think the court has to overrule.
Am I
Woodard.
correct to say that there is no way for us to go along with your position without overruling Woodard?
I think you're right to say that, Judge Finley. There's a case from the 11th Court of Appeals in which the 11th Court, in a published opinion, said Woodard doesn't mean what it appears to all of us. It appeared to the 9th Court in this case to mean.
Woodard doesn't mean what the 9th Court specifically said. Woodard.
There was a case from the 11th Court that said.
What does Woodard mean?
Woodard is a mistake. Woodard is a mistake. What Woodard should have said was.
What's the holding of Woodard?
Oh, I'm sorry.
For everyone.
So the holding of Woodard is that an offense is committed within an officer's presence or view when he has enough facts to reason that would lead a reasonable person to believe that the offense had been committed. Essentially, Woodard says presence or view is satisfied by probable cause.
Okay.
Under your conception of presence or view, how much does the officer have to see or observe or experience or whatever you want to say?
There are two parts to that question, Judge McClure. One of them is the officer himself, and the other is the police team, because there's a case called Beverly. I don't think that today is the day to overrule Beverly, but I think we're going to want to come back to
Man,
Beverly.
you're really swinging for the fences here.
That's what I do, Judge Newell. No,
Any other cases we need to take a look at?
not today. I can send you my list, Judge. So as the law stood at the time of Woodard, the law was that if a team of officers observed an offense being committed, and presence or view meant actual presence, actual view, that is, presence, did it happen where the officer was, when the officer was? View, could the officer see it happening? Which might be two different things, because the officer might view an offense through a telescope where it's not in the officer's presence, or the offense might happen in the officer's presence, but the lights are out and the officer doesn't see it happen, right? The lights come back on and Dangerous Dan McGrew has his smoking gun in his hand and the piano player's dead.
When does a felony intoxication manslaughter offense happen?
At the time of the death.
If that's the case, would not adopting your position effectively prevent officers from making a DWI arrest anytime there's a car crash with somebody who's allegedly intoxicated? Then the officer shows up 2 minutes later, 5 minutes later, 10 minutes later. If we adopt your position, doesn't that extend to that scenario when the officer can never make an arrest?
No, because of suspicious place and circumstances. The officer can make an arrest.
We addressed that a couple of.
Yes, an officer can make an arrest of a person in suspicious place and suspicious circumstances. Certainly, if there has been an accident and there is a guy leaning against a tree, there's one person there, he's leaning against a tree and he's clearly intoxicated. suspicious place, suspicious circumstance.
Did the lower courts at all embrace that idea with regard to this case? Was it
No.
the consideration of the
No.
hospital a suspicious place?
No, there was no discussion of that. And I think it's a dead end in this case, Judge Erie, because the hospital's not a suspicious place. It's a place where people who are injured go. And there's no
I
evidence
mean, the
of,
same kind of argument could be made about any particular place, right? That it's not suspicious. It's a classroom. It's a
Well-
courtroom. It's a, you know,
a hospital is a place where injured people go after accidents.
Well, take it to its logical extreme.
Yes,
There's a school shooting.
yes.
There's a report of, hey, a guy in a blue shirt with an AR-15. But the person who reports it is shot and killed. The police arrive. There's a report that there's a guy in a blue shirt with an open carry AR-15 in an ice cream joint 2 blocks away. The police show up. Now, are we saying because they haven't seen a crime being committed, they have no ability to arrest because he's not committing any crime? I mean, I realize that's a slightly different factual scenario, but I'm trying to parse out the ramifications of adopting the position you're advocating.
Okay, so the ramifications of adopting the position that I'm advocating, first of all, are to follow the words that the legislature has used. As far as the person who the police have reason to believe committed the school shooting, he's found at a location nearby.
an ice
I
cream
don't,
shop.
I ice cream, shop, right, where else would you go?
Suspicious ice cream shop.
I doesn't,
Suspicious. Yogurt is always very suspicious.
I don't know the answer. I don't know the
It's no
answer.
problem if we adopt your position.
Well, I see the larger problem if you don't, which is that an officer then can arrest anybody anywhere for any probable cause, which is not the legislative scheme.
Well, I actually want to say, I want to sort of, it's not an all or nothing thing, though. Like in these kinds of scenarios that we're talking about, the officer doesn't have to arrest them. The officer can still detain him, couldn't he?
Yes.
Could the officer in this case have arrested for public?
That's another
intoxication?
case we have to overrule, Judge. Miller.
See, I knew it. I knew it. I was gonna get behind it. There you go.
Have made the arrest for public intox?
Not in this case, because he was at the hospital. If he had come on the scene, the guy was out of his truck and was intoxicated, a danger to himself or others. He could have arrested him. In this case, I say not in this case. There's no evidence in this case that there was any evidence that Mr. Barber was a danger to himself or others at the hospital, which is what's required for public intoxication. So in the general DWI accident has happened, single car accident has happened. Cops come on the scene afterwards. You have that public
Okay,
intoxication
extend that. You're
situation.
talking about a contemporaneous report. We're talking about, hey, he might have been a danger to herself or others when the accident occurred, but now at the hospital, he's not. So let's import that. If this presence in view, does this not necessarily require a contemporaneous thing? In other words, in order to view a thing, you have to be there when it happens.
Yes.
For it to happen in your presence, you have to be there when it happens. Both of those imply a temporal proximity at the time, not an hour later, not 2 hours later, not a day later. Can the court just stand on that temporal proximity, that presence of view is at the same time?
Yes, that the offense has to happen at the same time the officer is there.
But that directly contradicts Woodard.
That directly contradicts Woodard. Yes, you have to overrule Woodard.
Do we have to decide, you mentioned that the offense happens when the person dies. So do we have to struggle then with questions like, when does death occur? Because I mean, I'm just a human that lives in the world and I've seen people raise questions about when death actually occurs. Does it occur when the person's heartbeat stops, when their brain waves stop?
Sure.
There's debate about that and
Actually, we can avoid that because the power to arrest for an offense within view includes an intoxication offense. It doesn't have to be the felony, any Chapter 49 offense. So the offense there is an offense committed at the moment of the driving while intoxicated, at the moment of the accident.
Well,
I may be wrong about the intox manslaughter being completed at the moment of death, but that seems to make the most sense that's when it's done. But none of that happened in the officer's presence or view in this case.
well,
But wait,
doesn't that- sorry.
no, go ahead, Judge.
I was gonna say like, well, so doesn't that actually open up an interesting possibility of, look, if it's when the death occurs, then all the police officer has to do is be there when the death occurs at the hospital. And then the offense becomes complete.
It might. If the officers, I concede that is it seems like a absurd result, but
So if we have an
right.
accident scene, the officer comes on it, there's beer cans spilling out of the back of the car. There's a gentleman walking out the driver's side, staggering away. and there's somebody needing urgent medical care not to expire, the officer renders medical care, but he doesn't examine the driver to determine that there's intoxication. You need both things for intoxication manslaughter, right? Can he make the arrest?
Can he arrest
Yeah.
the driver,
I'm
even
just
though
I'm
he's?
testing your attack
Right.
on
Right.
Woodard.
No,
At some point, you can reduce to absurdity the what amounts to presence or observation of the officer himself. How much does he have to observe? Because if he has to be there at the moment that the decedent expires, it's going to be kind of difficult to have.
Okay, but I don't, okay, so now we have driving while intoxicated, which is an offense, which not committed in the officer's presence. We have accident, which is an offense not committed in the officer's presence. And then we have the officer presence. And then at some point, maybe we have the decedent's demise, which I'm saying I think probably creates that intox manslaughter. So in that period between the accident and the demise, the officer is present. There's no offense committed there except probably for public intoxication. Which,
Let me take you back to the root of your argument.
yes,
You are seeking to exclude the result of the blood draw, correct? Okay, that is under 18067, that the officer executing the warrant has to be capable under the statute of making the arrest,
Yeah.
correct? Okay, so at the time, if I read your brief correctly, where the officers comes from Liberty County with what is otherwise a valid warrant, if I read your brief correctly, had he found a friend who was a peace officer anywhere in Harris County, who had walked with him to hand the warrant to the hospital staff, no problem, right?
correct. He could have tapped in a Harris County officer.
And what's the basis for the exclusion of this evidence? You've got this argument, 18067, subparagraph 2, no longer in the statute, right? But it was in the statute at the time. The officer executing that warrant has to understand that Woodard doesn't mean what Woodard said or is about to be reversed.
Article 38.23 doesn't depend on what the officer understands the law to be. The exclusionary rule requires the exclusion of evidence that's obtained in violation of the law. 18.067 was violated. It doesn't matter that the officer thought he had a good faith reason that the offense wasn't being committed, or that the statute wasn't being violated. The statute was violated, and 38.23 requires exclusion.
I have a
So
question
is
for you.
Exception relevant to that initial inquiry? Because
No.
how else is it? We have a limited period of time to get the blood drawn to be of probative value in the case. So we have a warrant issued out of Liberty County that's got to be executed at a hospital in Harris County. But in order to do this, the officer has to understand that he didn't see enough of this accident because he came on the accident scene, right? He saw the vehicles, but he didn't see your client inebriated. He had to go to the hospital to see that, but that's not enough to constitute presence. And he couldn't find a friend on his way to the hospital to hand the piece of paper, right?
Right. I'm afraid that your question, Presiding Judge Schenk, is not on my card. The question is it presence or view? If it's not actual presence or view, and the answer to that is clearly no. If the court would like additional briefing on the consequences of that, then I'm sure the parties would
That's the best
provide
answer
it.
I've had.
So
I don't think I
Question-
finished with
Oh, sorry.
Judge McClure's.
Go ahead.
Oh, no, 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 you
I'll
go,
yield
you
to
go.
you.
Okay. Officer gets, so same fact, everything's the same, except when the officer gets to your client's bedside, the officer, smells alcohol and thinks he's intoxicated. Has he observed the offense at that point?
I don't think so.
Like,
Not,
'cause it's
not,
been
not an
3
issue that's presented here, but I
Yeah.
don't.
Because I was thinking, I mean, it's been 3 hours, if I remember the timeline correctly, it's been 2.5, 3 hours. Once the officer gets to the hospital, hopefully, your client wasn't drinking at the hospital. So is any sign of intoxication at that point an indication that he's observing the offense?
I don't think so. There's nothing in the record about any sign of intoxication at that point. I think the state's brief is mistaken about that. I'm 4 seconds over. Presiding Judge Schenk, may I take
You
Judge
may.
Parker's question?
Yes.
I just wanted to go back to the issue of the plain meaning of the statute. We seem to be looking at a lot of speculation. And when you look at presence or plain view, if we take that out, then basically, you just are putting probable cause as a determination in about a half a dozen statutes. And then we have statutes where the legislature has not required presence or plain view. And so I'd just like to hear your summary comment maybe on the issue of plain meaning of the statute, a real simple way to dispose of the case.
Sure. The legislature has created this scheme of arrests without warrant, and by making it so that presence or view means essentially probable cause, this court has gutted that entire scheme. This is just the first step. The Barber case is just the first step forward from Woodard, where it's being applied to a situation that wasn't the Woodard situation. But there's no reason that the state wouldn't be saying, okay, well, if Woodard says that presence or view only requires essentially probable cause, and I think we can all agree that that's what Woodard says, then this other statute doesn't require it either, and that other statute doesn't require it either, and essentially any officer at least, and probably any human being, can arrest anybody for anything in Texas
Well,
with only probable cause.
not to jump on the judge's question, but does Woodard really say probable cause is enough?
No,
Okay.
it uses
But what-
words.
what if, and this is the problem, because whatever rule you want to write to try to reconcile these statutes is going to have to operate, not just for this case, but for every case in the state. The officer has some combination of personal observation and information on which he would base the probable cause, but we have an officer who is a witness enough to accidents that his testimony would be probative and admissible at the trial to prove some fact relevant in the offense. Is that enough, in your view, to reconcile Woodard and say, now we have observation of the officer himself?
I mean, you say observation of the officer himself. I'm not hearing observation of the offense. It is true that if the officer smells the odor of marijuana, but the people are inside the house, and then goes inside the house, that the offense has been committed in the officer's presence because the officer has some personal information about the offense. And I say personal information as opposed to, for
Yeah, but
example,
he doesn't know,
hearsay.
he doesn't know who was smoking it. There's
But
five people in the room.
Right,
But
that's the
point.
problem there,
You're-
right?
You're asking us to fix Woodard, but we got to get it to the point where, as you've seen from these hypotheticals you've been asked, there's going to be lots of circumstances where the offense, every fact that is of consequence in a subsequent trial is not going to be personally observed by the officer, like the death of the victim in intoxication manslaughter, but some of it will.
Right. And I think the answer is that I think the answer that this court's earlier cases came to was if the officer witnesses or is in the presence of some part of the offense, that's good enough. That the officer doesn't have to see everything that happened. The officer doesn't have to
Would
be
you
the drug.
okay with us saying that?
What's that?
Would you be okay with us saying that, or are you asking for something different?
Well, I mean, that gets us to Beverly. I mean, for today, for Woodard, I think the answer is that the officer has to, that offense committed in presence or view means the offense has to be committed in the officer's presence or view.
Could I ask you real quickly you said this, I'm seeing two statutes here. One is for the blood draw and one is for the arrest in officer's presence or view. For the sake of the audience, could you explain how the arrest in the presence of view translates to the suppression of blood evidence under another statute?
Sure. Before September of 2025, Article 18.067 of the Texas Code of Criminal Procedure required that an out-of-county officer serving a specific sort of warrant, a blood draw warrant, be in a contiguous county and be authorized to arrest the defendant. And so that's what we're fighting about here is that subsection B, authorized to arrest the defendant. The authorization to arrest a defendant without a warrant.
It doesn't say arrest the defendant. It says make an arrest. So the state's argument that this, as what Judge Newell's saying, this translation over the statute says you can serve a blood draw warrant in an adjacent county. And the statute says verbatim, by any law enforcement officer authorized to make an arrest in the county of execution. Taking that literally, it doesn't say authorized to make an arrest in this case. It doesn't say authorized to arrest the defendant. It just says authorized to make an arrest. The state could make the argument under certain circumstances, these officers are authorized to make the arrest in the county when there is presence or view, when there is this exception, when there is that exception. And therefore, we don't need to limit it to presence of view in this case. We don't need to limit it to these crimes in this case. The fact that the same technicality they're using, trying to shoehorn it into this case, would give them the grounds to say, if he can make an arrest under any circumstances in that county, then he can serve the warrant.
Yes.
And we
And-
know that
and-
the legislature's intent, when they changed the statute, was exactly that.
Now you feel our struggle.
Well, I do, except it's kind of strange because this was my first point of error. This was a point of error in which the court did not grant review. And
Not all the court made that decision.
Pardon me? Thank you.
Thank the shade.
Right. So yeah, I think that was an interesting question. It's no longer an interesting question because 18.067 is no longer says what it said. It's not an interesting, if that's not a question that we're able to brief here and argue about here, then I think we have to go with the presumption of the trial court and the Court of Appeals, which is that we're talking, and I think of the state and the defense below, which is that we're talking about authority to arrest this particular defendant in this particular instance.
Well, the statute, getting back to the strict technical language, it says he may execute the warrant, right? Doesn't say only he may, right? May is not the same as must or shall, right?
Well, that's interesting. I think below, we all treated it as
Well,
may.
it's not below anymore.
I know,
right? So-
we all treated it well, we didn't brief it because of that.
Well,
So I
that's
haven't
why
briefed
I
it
asked
in my
the
head.
question. But
But I think the answer is that if the legislature says an officer may do X, it's necessarily exclusive.
I'm not going to quibble on that. I think I'm with you. My point is about how we construct the statute in a way that's consistent with overall legislative intent, related statutes, and common sense in a way that can work for fixing Woodard. And I'll just throw this out there as my last question to you. I mean, we have the legislature putting whatever brakes on in terms of personal observation and presence. And we also have a judge who has issued a warrant. And we have the judicial branch and we have the legislative branch. So consider the hypothetical for when you get back up on rebuttal of, I don't care what the legislature has said here. I am a judge of Article 5 of the Constitution. That rascal is over there. I am directing you, Constable, serve my warrant. What answer?
Okay.
Thank you.
I have one comment, one question. Who is responsible for fixing the statute unless it leads to absurd results or, so it doesn't seem to me, I mean, we can postulate all these various hypotheticals and why the statute doesn't work, but is it really our job or the legislature's job to take care of what they've actually put in the statute repeatedly, and then in other sections they've intentionally left out?
It's the legislature's job to get it right, and the legislature just wrote the law as it had been for the previous 300 years. If they want to change it, they can change it. I'm not saying the legislature can't change it. I'm saying this court can't change it.
And I grab them. May it please this honorable court, I'm Jennifer Bergman, the elected district attorney of Liberty County, Texas. I'm here with Michael Matthews, also representing Liberty County.
First question for you, before you even start.
I don't even get to say
Do
anything.
we have to rewrite the statute, in your view, to construe the words presence and observation for you to win?
I don't think you do. And I don't think that you need to redefine what presence or view is. I think you only need to recognize that an officer personally observes a suspect during the immediate aftermath of a fatal intoxication offense is still seen as observing that intoxication offense.
But
So
the officer didn't see the defendant drink. He got a report from a witness who said, I saw that person drink 2 drinks.
Correct. But when he arrived at the hospital with this warrant, the defendant is still intoxicated. So
Getting information upon which you base your decision from a non-law enforcement officer somewhere saying, I saw him drink. I mean, how do we reconcile that with in the presence or view?
I think that, we always tell juries during voir dire that we have to not forget our common sense, and we have to look at the totality of the circumstances. The bartender was the one that informed the officers that she served at least 2 beers to this defendant. So you know, you look at all the evidence. Officer Ibarra arrived on scene. There's been a big deal made of it. It took 40 minutes to get there. And I don't know if any of you have ever been to Liberty County, but it is a rural county. We may be adjacent to Harris County, but it is not urban. And 40 minutes, that is really not a long time to pass. And then in order to get a warrant, Officer Ibarra had to drive all the way to Liberty. And so that took to the judge's house. So that took another 25 or 30 minutes, and then drive all the way to Harris County, which took another hour to get to the hospital. And so it's very important that these things happen in a very quick manner. And this was quick. And I know
Is there a
that
distinction between what the officer had to show to get the blood warrant and what the officer could have shown the same judge at the same time to get an arrest warrant?
I believe that the officer, and I can't really answer that. I think that he may have wanted to see the defendant at the hospital. I don't know what his thought
Was the
process
defendant
was.
under arrest at,
He was not under arrest at the hospital. He left the scene relatively quickly after the accident and was taken from the scene to the hospital. There were more, it's not in the record, but there were more vehicles involved than just the decedent and Mr. Barber. And so there were additional witnesses that were present.
When was the victim moved? And I mean, was the officer on the scene when the victim was still there?
I'm not sure about the answer to that, but I can tell you generally it takes our JPs come out and do that. And so it will take a couple of hours
So
usually.
there's potentially, anyway, there hadn't been anyone declare him to be deceased at that point.
That is quite possible.
So he could have been on the scene and seen the victim in the car as he expired.
That's correct. I would be shocked if by the time Officer Ibarra arrived to the accident scene in Liberty County that the decedent had been moved from the scene.
I don't have my code of criminal procedure in front of me. I recall there being a chapter with definitions in it.
Yes, sir.
Is there a definition anywhere in the code of criminal procedure for presence or view?
There is not.
Okay, so let's get to the officer's perspective here. We are debating and haven't answered the extent to which we love Woodard or we don't. Officer Ibarra has a warrant validly issued out of Liberty County. He has got to make a judgment about whether he has observed enough of the crime scene and the individual to execute the warrant himself, correct?
Correct.
And if he's supposed to make that determination on his way to the hospital and to determine whether he has to phone a friend and find someone in Harris County to come with him to hand the piece of paper to the hospital staff, correct?
That would be correct.
Okay, so without a definition in the statute for presence or view, is it appropriate for this court to supersede a reasonable judgment of a police officer about whether he has viewed some or enough of that aspect of the offense to be authorized to execute that warrant?
I would not believe it would be. I will say that when Officer Ibarra arrived on scene, the crash scene was still there. All the vehicles were still there. More than likely, like I said, the decedent is still covered, but still there. Witnesses had been spoken to. He spoke with the bartender who said that she had served alcohol to the defendant. And that crash happened as the defendant was pulling out of the bar. So he pulled out of the bar into the public roadway, and that is exactly where the crash happened. So if we're talking about suspicious place and he's driving away from the bar and there's nothing else around there but fields and there's a bar. And that's exactly where the crash happened. It didn't happen down the road. It didn't happen an hour after he left. It happened moments afterwards.
Was
Well, are
the
we gonna
trial
put-
court offered the opportunity to consider whether this was a suspicious place justified arrest?
That was not something that was mentioned. The trial court really wanted to rely solely on the fact that there was not an officer
I mean,
there.
Did the state bring that to the attention as a possible avenue for affirming what this officer had done?
No, sir.
Okay.
Judge
Better
Shank
for
has.
consideration
oh.
of Woodard, I guess.
well, how much is, how do we determine what's immediate? Like you're saying this is necessary to say it happened after the offense and the officer had to say it was immediately after. So that gives you the whole context of the offense. How long after does it stop being immediate?
I mean, I think that that's all situational. And it's all fact specific. Immediate would be in Liberty County, immediately arrive on scene could be longer than it would take for officers to immediately arrive at SMU to respond to something. So they're arriving immediately, but they're still viewing that scene. And they're still viewing, I would say, the offense itself.
So
Because-
you're taking us away from the idea of presence and just saying that this would fall under view.
Correct. But he did have, it was in his presence too, to observe this defendant in the hospital. And,
I
you
know,
know,
what did he observe of the defendant in the hospital? I mean,
that he was intoxicated. He
Okay,
was
where-
still intoxicated when he
okay,
arrived at
but
the
where,
hospital.
how did the officer know that he was intoxicated?
I believe that he exhibited signs of intoxication, smelled of alcohol, all of those things. Those are not in the record.
Yeah, okay, that's what I'm thinking of.
But, you know, those are things that would have been, I guess, or could be articulated in a full-blown evidentiary hearing with Officer Ibarra.
And then I guess my next question is, I mean, Judge Shank, I loved how he put it, the phone a friend, right? Like, what public policy do you think the phone a friend scheme serves?
I really don't think that I don't know what it serves
Well,
because
let
we
me-
had to do that.
Let me tell you my answer, okay?
Okay, I
So,
want to know.
if I'm a voter in Harris County, I don't have control over peace officers in Liberty County, or I don't have control over the people who hire the officers in Liberty County. So perhaps if there's a crime in my county, maybe I want my county's officers to be involved in that and not have, and I'm not picking on Liberty County. I mean, I'm sure Liberty County doesn't want Harris County officers running around all over Liberty County doing stuff without Liberty County officers. I mean, do you see that might be an important public policy
I
consideration?
see that, but this is just the service of a warrant for a blood draw.
Yeah, but it's the statute, just like Judge McClure and Judge Parker said. And Judge McClure's given an example of what public policy might be at play here. But our job is to interpret the statute, the plain language of the statute. And the plain language of the statute is presence and view. If I ask anybody in here, what does view mean? They're gonna say, you can see it. If I ask anybody in here, what does present mean? They're gonna mean same room, same place. I'm
Or
there.
view.
So if the statute says presence or view, how do we get past presence or view?
But it also is determinative how much do they have to have in their presence and in their view? I mean,
The crime, that's what the statute says. It says.
but if
The
you,
offense.
if
Any
you,
law enforcement officer authorized to make an arrest, and then the statute that piggybacks on is presence or view.
correct, but if you take the view of what the defense is arguing, no officer, unless they somehow saw an intoxication offense or an intoxication manslaughter in front of their face,
And that's the
would,
normal DWI. The normal DWI is initiated by an officer personally observing, and that falls within the offense committed in his presence or within his view. The vast majority of DWIs are not somebody reported the guy leaving a bar. They are the officer's driving along, he witnesses suspicious activity, he follows the car, he observes it.
or there's the DWI where there's a crash has occurred and they investigate it that way. And that would fall under this same set of circumstances. I think that if you narrowly define it the way the defense is asking you to, you're really,
If we narrowly define it the way everyone understands it, would be a more accurate way to put that.
except for Woodard.
Except.
I mean, I'm a big cheerleader of Woodard.
That was my first.
What do you think about Beverly?
I mean, that's on this guy. He wants to talk about Beverly. But no, I like Woodard and I think that
Oh, I'm right. Like Woodard, what do you make of counsel's argument that that portion of Woodard is dicta?
I think that he argues that words have meaning and then he says, but these words don't have meaning. Because he wants the words he wants to have meaning, but not these.
What
And
he's
that,
saying is the words in the statute have meaning, but the words in dicta, the non-binding portion of the holding, don't carry that same level of meaning. I tend to agree with that. The words in the statute have meaning.
What,
We are to interpret them in
the
those
words
plain
are not
language.
defined in the statute, correct?
that's correct. And I believe your words have a lot of meaning and your words in
I was feeling so insecure up until that point. Thank you. What am I doing here?
We don't write the law, we just interpret. How do we interpret within, the language to me, for any offense committed in his presence or within his view?
But I think that, I guess Judge McClure, sorry, mentioned it, that when he arrived at the hospital, that is still, it's not just an intoxication offense is not just a snapshot. It's not a still shot of what is happening. It's those, it continues. So it started before the accident occurred, and it was at the time of the accident, and it continued onward until he's not intoxicated. And when Officer Ibarra was at the hospital, still intoxicated.
Go back to Officer Ibarra's thinking for me. He goes to the judge and he gets a blood warrant. He's not going to get the result of that for weeks. He's at the judge. The same evidence that gets him the warrant will get him an arrest. So he's clearly either not planning to make an arrest because he'd asked for an arrest warrant, or he is planning to make an arrest and he doesn't care about the warrant. But if he's at the judge, you made a comment. He drove there, he drove back, understood. But he's at the judge. He's presenting his evidence. He's got his information. He's presenting enough evidence, trial court said, to support probable cause to get the warrant. Why is he not getting an arrest warrant as well?
I mean, if I knew why Officer Ibarra, lots of law enforcement officers do the things that they do, I mean, if I had a nickel for every time I tried to understand that, I'd be a millionaire. I don't.
That's so liberty.
Officer Ibarra.
Well, and by I think you might be saying that because did he draw the blood himself?
No.
Okay, somebody else actually drew the blood.
Oh, yes.
So should we be thinking about distinctions between executing a warrant and drawing the blood? Or, I mean, is drawing the blood what was ordered by the magistrate judge?
Yes.
Magistrate
Yes.
judge ordered the drawing of the blood.
Blood.
And it wasn't, arguably anyway, it wasn't the officer who drew the blood.
No,
It's somebody else.
he's an illegal courier, right?
Yes. He did. He illegally gave it to him.
What do you think
and
about
Instructed
Bennett?
the hospital staff.
Well, again, though, you're saying that the defendant wasn't under arrest at the time the arrest warrant or this blood search warrant was executed?
That's correct. The ambulance took him to the hospital rather quickly.
Okay.
And that's what we want to have happen, right? We don't want officers to stay on scene and say, oh, wait, please don't
No,
take
no, you
this.
have to stay in
You have
Liberty
to say,
County.
I need to see this. I need to finish my investigation.
And I grant you, it seems absurd that this evidence would be thrown out and this warrant invalidated because the wrong officer handed it to the tech. But the statute says what the statute says. The legislator wrote it the way they wrote it. We can't just change it because we don't like it.
Let me ask you a question about that.
Oh, dear.
Is there a plain language reading of the word
Great.
presence or view by which Officer Ibarra, having taken upon himself the effort to go drive to find a judge at home at night and get the warrant to draw the blood, concluded, I was at the scene. I personally viewed and observed evidence of the offense itself to the point that it would be relevant for me to testify later. I cannot give this warrant to some other officer of this county and send him over. I have to be the one because I viewed at least enough of it to be a potential fact witness at trial. So I have to drive to the county and deliver it myself. That would be a plain reading language of the statute, right?
Yes, sir.
That would work, but didn't he mark out it wasn't in his view on the affidavit? I believe there were either the search warrant or, let's see. I think he put a mark somewhere that said that where you marked plain view or whatever, he marked that, made a
I
mark
think that he
noting.
did not observe him operating the vehicle or something along those lines.
Out of his way.
Yeah.
To be completely candid with the magistrate, to be completely, he's not whipping anything. He's not avoiding any spaces. He's being very, very thorough to be
Mhm.
completely candid with the magistrate. He strikes out the observation. I mean, from coming from the defense background, I get the fact of the exclusionary rule, et cetera, when we're engaged here with law enforcement misconduct. But this law enforcement officer not only did he not seem to engage in any misconduct, he seemed to have gone above and beyond to be overly candid and frank with people. I mean, how do we parse that?
You say Woodard is great. But I will say too, and we didn't brief this issue, and I'd be happy to do that with you guys. But as I was going through this, our brief talks about, collective knowledge, but there's also the possibility of this idea of collective authority, because the statute doesn't just give a peace officer the ability to arrest when they see a felony or they see under these certain specific instances. They give any person
Yeah,
to- the ability to do that.
Slope. If you go with that argument, that means that by extending presence in view means that any non-law enforcement officer is going to be able to make an arrest when they have probable cause.
Yeah, but
even if
that's
it's
not a-
presence or view.
But that's not our problem. The only problem we've got here, the basis for the exclusion is the identity of the person who handed the warrant to the hospital staff, right?
Yes.
What was the, at the time of the offense, what was the law on the legal limit? Was it 0.08?
0.08.
Okay,
Yeah.
I really don't. And I'm reading here that when they did this blood toxicology test, it was 0.079. That's just as close to 0.08.
Yes,
So
sir.
my question is, was the defendant alone after the accident without the police officer seeing him? Because he could have had a pint in his back pocket and drank it all real quick.
I mean, that's possible, but although it's not in the record, there is no evidence that that occurred. I think he was injured rather significantly that they took him to a hospital in Harris County. So Liberty County only has a freestanding ER and a kind of very basic hospital. So if you would only go out of county if you needed more substantial medical services.
Maybe the ambulance driver gave him a pint.
I mean,
Should presence in view mean something different when we're talking about law enforcement than we're talking about a civilian making an arrest?
I think that you have to look at all of the circumstances, and I think that it should not. But he saw the crime, he saw the crime scene, the individuals that were hit, there were other individuals that were hit. They saw him pull out of the bar. Any of those people, I would argue that's not in the record. I'm going to be real candid with you. But all of those individuals, including the person that watched him drink alcohol, in theory, could have effectuated an
They
arrest.
actually observed it. Correct. You're arguing for an interpretation of presence in view that would allow somebody who was in the bar, who was told by somebody who said they did until later arrest him and they didn't see
Well,
it.
in theory, no.
Of course, the legislature's aware, we should presume, that there may be many people who observe all or part of the events giving rise to a criminal offense, right?
Yes, sir.
And a plain language construction of presence or view that would include the officer's personal presence or view of facts that would be relevant at subsequent trial or enough to preclude anybody serving a warrant based on hearsay, which would be most of the law enforcement officers you have in Liberty County who were not at the scene to observe the vehicle in pieces, broken glass, and the like at the crime scene, right?
Yes, sir.
So what is your definition of presence or plain view? How would you like the court, were we to rule with you to, I mean, if we were to clarify Woodard?
I think that it would need to be the facts and circumstances that the officer observed at the time of the offense, including the scene, including the intoxicated individual themselves. You look at all of those things and not just in their plain view. It doesn't have to be, they don't have to see someone behind the steering wheel.
And how does
And
that not just turn presence view into probable cause? If it's just the totality of their information, how does that not just eliminate presence of view and say the officer can arrest when he has probable cause based on what he's seen, what he's been told, what he's observed?
because there are things that he personally observed and saw. So I think it's a combination of those things, especially in this type of crime. Because otherwise you're going to have a chilling effect that you're almost never going to be able to arrest someone without a warrant for an intoxication
Isn't that
manslaughter.
what found cause intended?
No, the legislature clearly wants a carve-out provision for these.
Carve-out exception for
Correct.
offenses that occur in the presence or view of the officer.
And if elements of the crime, it doesn't say that you have to have all of the elements of the crime be in the officer's presence or view. He doesn't have to watch the defendant drink beer in the bar in order to know or have the knowledge that he had been drinking. He doesn't, I don't
That's not what it
believe-
says. It doesn't say the officer may arrest when a substantial part of the offense has occurred in the presence of view or significant aspects of it. It says the offense occurs in his presence or view. Right?
Correct.
Okay, and to me, offense is all of it, the offense, presence or view. And I'm trying to figure out a way how to get away from or
In
around.
intoxication manslaughter, the driver has to be intoxicated.
Correct.
There has to be a decedent.
Yes.
It has to be causation.
You've done
We want to provide medical care to these people. They're going to be trucked away from the scene. Is the legislature aware of the fact that they may be going two different places?
Yes.
a probable cause and presence in plain view. They don't have to necessarily be mutually exclusive based on what I'm hearing you say.
Correct.
So.
Anything else, counsel? Thank you very much. I think we've got your argument. We'll now hear a rebuttal.
Thank you. Forgive me, I was trying to do too many things at once and I forgot who it was that hypothesized that the blood draw could be the execution of the warrant.
Me.
Thank you. It can't be. If you look at the warrant, it directs the officer to take the person to a physician to draw the blood. So much of that was outside the record. The court has the record. The stipulation of evidence doesn't even include this fact that the officer saw the scene of the accident.
That's problematic, right?
But that's, yeah, certainly for the state's argument, that's problematic in this case. Now, does it affect yeah, I mean, it has to be problematic. And they have to say that he saw these things in order to make it a greater problem. It's not in the record. The stipulation is at clerk's record 25. I think the warrant affidavit is attached. That's not there.
Does the statute contemplate the idea of the collective knowledge of officers?
That's Beverly. And I think not.
Okay.
I think, well, I take it back. As long as the officer who's making the arrest, it does. As long as the officer who's making the arrest is in the presence or view, as long as the offense is in the presence or view.
Say the whole offense occurs in front of officers, in your view, but one of the officers that wasn't there does the arrest, in your view, it would seem like the collection of knowledge of the officer would allow that to be in the presence of view because it occurred in front of officers.
That's the Beverly case, and I think that Beverly is going to need to be revisited in light of Boykin. Because in Boykin, the court said that we follow the plain language of the statute, and Beverly doesn't follow the plain language of the statute.
Excuse me, let me
Not
take it
the
back
date
to
Yes.
that question on what the record shows. What's your best case for the proposition that your motion to suppress based on who delivered, who executed or served the warrant did not observe or view the offense? Was it not the motion? Did not motion not carry that burden?
Yes, and the findings of fact are that that Officer Ibarra, that the offense did not occur in Officer Ibarra's presence or view. So, and I think that aside from whether, unless presence or view could be probable cause, which would be a legal question, which this court would review de novo, I think that factual finding is binding on this court. I think the court.
Well, actually, though,
Take that back.
that kind of does raise a question. Is the finding that it occurred in the presence or view a legal determination or a factual determination?
I think it's a mixed determination here, and that's why we're here, is because of that Woodard raises the question of whether presence in view means presence or view.
Mhm.
The definition of the word is a legal question, I think.
Can you explain to me why was the trial court judge tied down to this? Because chapter 14 has how many different options for when an officer can make an arrest? Why was the trial judge apparently so utterly focused on this particular provision and whether the officer was permitted to arrest under this provision as opposed to some other provision?
This is the one with a caveat. This is the one that closest applies. It actually, I think, should have been 14.03 G2, which is a municipal officer's power to arrest outside of his own jurisdiction. But it's the one that most closely fits the facts. I think that if the parties in the court below in the trial court had thought that suspicious place or circumstances had been a better argument, that they would have made that argument, or they would have made it in the Court of Appeals. And I don't think that this court now has information from which it could go back and say post hoc, well, it may not have been presence or view, but it was suspicious place, suspicious circumstances.
But your argument about execution of the warrant, is it necessarily tied to whether the officer had the authority to effectuate an arrest? I mean, or are those two separate things?
At the time, the statute required the authority that the officer have the authority to effectuate the arrest in order for the officer to be permitted to, and I haven't forgotten your question.
But it's subject to the words may and
For the officer to be permitted by statute to execute the warrant.
So
And so
if-
that's how they're tied together.
If we find that the Court of Appeals should have been looking at a different section, or that the trial court should have considered the officer's authority to arrest under a different section of chapter 14, what should we do under those circumstances?
I suppose send it back to the Court of Appeals to consider whether that applies rather than this.
Well, this is a pretrial motion to suppress.
Yes.
Yeah, so the state could make a different argument later, regardless of what we say in this case. They could always say, should reconsider the motion to suppress because there's an additional justification for why.
Is that
be law of
true?
the
I think
case.
it's law of the case.
No, you can say that that it was bad because you didn't have a justification for offense in plain view. But if you're saying that it's possible that they could make the arrest under a suspicious place, they could always come back and say, you know what, the search was good because the authority to arrest under a suspicious place would be.
I think that wasn't argued below because
Right, it
it's
wasn't
not,
argued.
because it's not possible. I don't know procedurally that you could swing, that after this has all been litigated so meticulously by Mr. Pickett and by,
Well, it's an interlocutory appeal though. Right? I mean,
Yes.
we haven't finished.
We haven't had a trial yet.
Yeah, we haven't had trial yet. They can always ask the judge to reconsider. I mean, you're right. They will be judged. They will be stuck with the law of the case on this particular issue. But if there's another justification.
it's a mandate rule that.
Yeah, right.
Do we even need to reach Woodard if the findings of fact stipulate that the offense did not occur in the presence of the officer? Do we have to even get into the definition of?
What's the standard of review for that?
right. I mean, my best guess is that it's a mixed question because what is presence or view is a legal question. And is that standard satisfied is a factual question. So if the trial court, I think that if a court of appeals looks at it and says, okay, the trial court must have misunderstood what presence or view means. That's the only way that the trial court could have come to this conclusion. Then I think that is a legal question with de novo review,
Which we could look at. Right.
which is appropriate for this appeal. So the legislature creates the power to issue search warrants. And I think the legislature can limit those warrants any way that it wants to. The counter argument, the common law counter argument is that surely courts, and I haven't looked at it, of course, but surely courts had the authority to issue search warrants before we statutorized everything. And so maybe with the legislature claiming the authority to limit it is a violation of separation of powers. Don't think
The
that
legislature passed a bill that says in Dallas County, forget the special county and geographic prohibitions, a judgment may only be executed in Dallas County by a constable over 5'6".
Constitutional, but stupid.
Yeah, you see where I'm going. I'm not talking about their instance of the constable. I'm talking about the power of the judge to say, I am exercising a power here in my lane. I have issued a warrant that the legislature's authorized me to issue, correct? You don't, right now, there's not a dispute about that. And I want it served. So the legislature is pulling back.
I don't.
Isn't one interpretation of the word may a recognition of authority, not necessarily a discretionary call?
Yes.
Yeah.
And I think in the statute, that's how it's meant is
yeah.
to a limited grant of authority to do
Yeah.
this thing. It doesn't
And
make
that would
sense
be
otherwise.
consistent with
Has
your
this
view
court
about the
ever
authority.
said that in an opinion?
I don't know.
Is-
No idea.
So that would be law if it was in an opinion?
I've got Westlaw looking at.
Doing great.
The issue of presence and view and your request that we overrule Woodard. This was the issue in Woodard. Keller dissented and specifically said presence and view mean presence and view. So this is the same argument in Woodard. We're just being asked to readdress it, right?
Yes.
And you're
yes.
advocating that we just adopt Keller's dissent in Woodard.
It was a very brief dissent, but
What
I
is
think
it?
it's all that needed to be said was presence review means actual presence review. Unless there are more questions?
No, I think not. All right.
I thank you for your time. We ask that the court reverse the judgment of the Court of Appeals and send it back with instructions accordingly, whatever those are. Thank you for your time.
Thank you both very much for a very fine argument. The case will now be taken under submission and we will stand at recess. We will not stand up and exit because we're going to take questions. Our bailiff will do the rest.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals now stands subject to the call of the presiding judge.
Okay, well, thank you all very much for joining us for this argument. It's been our pleasure to be here at SMU to hear these arguments. We have two very interesting cases, both well presented. We'd now like to open it up to questions from you. Please understand, though, that we will not be discussing the particulars of this case, the merits of it, because we haven't decided it yet, and we needed to go back and do that. So with that, I'll open up the floor to anyone who has any questions about anything. Surely someone will be brave enough to be the first to ask a question.
Question.
Yeah.
Judge Audrey Moorhead, yeah.
The case people are on bed, and how do you decide which ones is to come and handle argument? Who makes those decisions?
Well, we get cases in various forms. We hear cases like this one. This is a direct appeal authorized by statute because it as a suppression issue. And we have discretionary jurisdiction to take these cases from the courts of appeals. You know, now we have 14 courts of appeals that might be hearing cases like this. And that's, I'm not sure how many total, but we're probably granting 50, 60, maybe less of those a year. And in oral arguments, if we get 4 people to grant, 3 to have oral argument, we're having oral argument. We probably argue about 10, 12 cases a year, something like that. We have a writ docket for habeas and other mandamus prohibition, things like that, that is much larger. We're talking thousands of cases, and that's a major task of going through those and deciding which of them have potential merit and what to do with them. And generally, we don't hear oral arguments in those habeas cases. That's a point that I personally think we should reconsider. I'd like to hear, particularly in death cases, from the lawyers and have a chance to ask questions. I find it, this is now me speaking, I'm inviting others to talk, extremely helpful to be able to engage with the lawyers. And you will see from time to time that the judges might really be talking to each other through the lawyers in ways that I think are more helpful than just sitting back in the conference room. So we're disposing of about 6,000, 7,000 cases a year. And at the time, back in 1981, when we divided, or we first gave the intermediate appellate courts criminal jurisdiction, we were handling less cases than we are right now. And the idea was it's just too much volume for 9 judges to try to push through. So it's a lot of work. Any other thoughts?
Well, I would point out that the court's docket has dropped in the last 10 years. I kind of feel like I'm living through the golden age of the Court of Criminal Appeals right now, because when I came on 9 years ago, it was a much greater volume than it is right now. So felony writs are primarily responsible. Those have dropped a lot for various reasons over the years. And I just hope it doesn't go back up.
Yes.
So I've always wondered this about the courts of appeals of all levels in general, but how much, like for oral arguments, how much does the arguments the attorneys make actually change your decision versus just what you know coming in when you first sit down?
So I want to answer that because I'm a big proponent of oral argument. I think it's a big part of the puzzle for me as a judge on an appellate court. You know, particularly at this appellate court, right? Because I have never worked at a different appellate court, but I understand because I was an advocate for 25 years. I argued cases in front of courts of appeals that many times our intermediate courts of appeals will already have drafted a proposed opinion resolving the case by the time they come to oral argument. Well, that doesn't happen here. By the time we come to oral argument, the most that we have had a discussion about any case is, should we grant review and consider the question presented in that case? That's the discussion that we've had. We haven't really sat down and talked about the merits of the case together until we come into a room with the lawyers and start talking to those lawyers about the case. And then we immediately go from here back to our conference room where we sit down and discuss primarily what those lawyers just argued to us. So you could see from my description of that, perhaps, that I think the oral arguments are incredibly important. I mean, in shaping the way we think about the issues that have been presented to the court. I know people disagree with me about that, right? Some people say, oh, oral argument will never change my mind, or, well, maybe you shouldn't be making your mind up before you come to oral argument. Come here open-minded and listen and see where it takes you. I sometimes think I know what the answer is before I come here to oral argument. But I'm always open to the possibility my mind could be changed here in this room. And sometimes if it's not changed, it certainly is settled, right? So.
Well, I served on the Court of Appeals that sits here, and we did not come into oral argument with the opinions pre-drafted to sort of go through autopilot. I agree and disagree with Judge Uri a little bit. I think I also worked on the Fifth Circuit for a year after coming out of law school, and I don't think often that you see what the advocate says at oral argument illuminating a light bulb above the head of the judge. So that's a thought I've never had, and now this case is going to be decided another way because we've read the briefs and we come in with a basic sense of where we want to go. But that's why argument, in my view, is so helpful, because we're testing. Like, you probably could see some of that today. I have a thought, and tell me why you think I'm wrong, and tell me where you think this should go. And very rarely are cases binary, right? It's not like, okay, yes or no. There's lots of ways you can get to each one of those potential outcomes and paths to choose. And that's what I think is so helpful about the oral argument is just testing these propositions and giving the advocates a chance to take care of their clients. I mean, this is the best we have, in my view, of this legal system. And my biggest objection to becoming an appellate judge when I was serving on this court is, like, you disappear. You were a lawyer, you were out there in the world, and all of a sudden you go behind a curtain and lawyers are over there and they're somewhere else, and you don't get to talk about what these cases mean. And I think it's extremely helpful, and it's cathartic, frankly, for the public to see that somebody is paying attention to their cases. And if we're going to deprive somebody of their liberty or potentially their life, I think it's helpful for those people and everybody affected by the case in the community to see that there's somebody who's independent, honest, and fair, that's studying these legal questions. And we have lots of statutes to govern what we do here, and sometimes they're better written than others. And we all struggle together to try to get to a result that seems reasonable and predictable. And the lawyers have a part of that job to play. And I think when they play it well in front of us, it helps us a great deal. Any other thoughts?
Just briefly, do remember there's a really big difference between witnesses testifying at the trial court, right? Where their credibility, their demeanor, their body language is virtually everything. And as a trial judge, you're looking at the demeanor and the credibility of the lawyer and the particular counsel that are in front of you. But here, that's not what we're looking at. The facts are already in the records. We're not looking at the people that are arguing in front of us to see, are they telling me the truth? Are they being credible? That sort of value judgment is why we give so much deference to the rulings of the trial court, because they're there to see the witnesses. They're there to see their demeanor. And so oral argument here is really much more about ideas and concepts, directing the judges to a particular thought path, as opposed to the credibility or the significance of, or the actual skilled advocates themselves. There's a really critical difference.
Any other questions? Yes, ma'am.
My name is Quentin Kelly, and I'm a 1L, just so you guys know. I was curious what technique or style of oral argumentation you find most persuasive and or communicates the theories that you were talking about most clearly.
Well, I would say that it's not necessarily a style, but there is a definite technique that I think typically works when we ask, as you're hearing a lot of questions going back and forth. And the advocates did a wonderful job having to field a million questions at once. But typically a good way to approach it is always to be like, I'm going to answer with a very short declarative answer, and then I'm going to expand on it. And that's sort of the best way to sort of do that. And in fact, even more than that, you can also say, clarify the question too, before you even give the answer. As I understand your question, you're asking this, and I think you would say no or yes to whatever the question is, but then you would expand on what your justification for it is.
I think that's exactly right. I mean, the critical thing is answer the question. And if you've been in, I mean, when I was on the fifth, I think we probably had, I don't know, 600 oral arguments. I mean, you give the lawyer a chance to win and you ask a hard question. And what ends up happening, you'll see it. If you watch enough arguments, the lawyer sort of won't answer. He'll duck, he'll move, he'll go over, give him another chance, and he'll move. And I find, for instance, today you saw some lawyers being very frank, very direct, not digging holes for themselves in issues that they're not going to make a lot of progress with. And this is not a fight, it's a conversation, right? And we're not here, we don't have an interest in the outcome of any of these cases. So it's just, if the lawyer is engaged in the same way, it's very helpful. You're here to help the court make a decision that's potentially difficult and help the law develop in a way that other judges will be able to follow in some predictable path. I've also seen, just to answer directly your question, lawyers come with a lot of exhibits like giant foam boards, and I don't care for that because I end up like going back and forth. It's not show and tell. We've all read the briefs. So just tell me, answer the question.
And stay out of the middle. You don't have enough time to argue all your points. You will never have enough time to argue all your points. You don't even have enough time to argue one point well. Okay, so figure out what's your strongest and what's your strongest argument in that point, and figure out what's your worst point, i.e. the other side's worst point. Be prepared to respond, but don't come in thinking you're going to have time to argue all your points. Pick your strongest point and hammer it, because we're not going to go back there and spend 3 days looking at the totality of the various argument nuances. We're looking for something where we can go, bang, there's no harm there. Or bang, that wasn't preserved. We're looking for something dispositive. So focus on it, give it to us.
There's part of that, something comes with that. Is you will do, I think, are you required to do moot court here? You should be. I'm required.
Where's the dean?
I am
We can talk about Beverly and Woodard.
If you are talking to a judge, it should not be a process of discovery within your own mind. Right? I mean, I would, you should ask somebody who is a friend and smart to walk through this argument with you, because there are going to be predictable questions that are hard for your side of the case. And I've been there, and despite doing moots, where a judge asks a really good hypothetical question and you realize on the spot and in that moment, like, I know what the right answer to that is, and it's not good for me. And if you have a week, you can get an answer.
I will tell you, which is, I think, an encouragement for you to apply to be a clerk or whatever, because look, when I was a law student, when I was a 1L, I did the very second question I was asked in my moot court experience, I conceded my entire argument. Okay, so don't do that. But I was going to add too that you and look at me now. But I was going to add though that you should also shy away from realize that the arguments for here are not the same as an argument that you might use to for trial. I always think of it, I guess I loosely conceptualize it as trial is like a movie or a play, and it's really dramatic and you're hitting a lot of emotional notes, and there's dramatic stuff in books as well, but this is more like you're talking about a good book. And so you can be dramatic and you can be emotionally impactful, but it's a much more richer kind of experience when you're dealing with text. So you should not be trying. I remember seeing one advocate once specifically making that kind of argument, turn the entire court off because we stopped listening to her, and she knew that we stopped listening to her. So she started making her argument to the gallery, like to the people, which is like, well, that's not effective at all. So.
And I would like to say to the students, something that you probably would like to ask, but you wouldn't ask, is that all the attorneys on both of those cases did a fantastic job. You saw some of the best today.
Before we wrap up, if y'all want to do a pitch for law clerk applications, and we'll take a brief.
How many, raise your hand if you're like a 1L, a lot of 1Ls out here, right?
They're all one.
And you have any interest at all in clerking for a judge when you graduate? That's a lot. So I'm just saying, consider sending in your applications to be considered for internships and law clerk positions, because a lot of, myself, I hire a new law clerk every single year. Sometimes in the summer, I take on interns, typically two, one for the first half and one for the second half. A lot of judges do it different ways. I know one of the judges on this court, just this morning, we were talking about it, said that they would like to have a law clerk serve for 2 years, right? In my chamber, it's only going to be one. I tell them up front, 1 year. And I have the young man over there who did our OYAs today will be clerking for me starting in September of this year. So SMU, first time I've been here, but you got great students, and don't sell yourself short. Give it a shot. The most that could happen is the judge could say, no, I'm hiring someone. So think about it.
I will add on to that. Look, you're learning all the statutes and the skills and the this and the that. That's great. But ultimately, your utilization of the law is predictive. You're going to advise your clients. What's the likely outcome? How do I likely achieve this? It's predictive. Your main skill set is advising your clients how to use the law to not run afoul of it or to accomplish their goals. Right? And a big part of that is how judges think. And there is no better way to learn how judges think than to be a law clerk. Go work with the judge. Go work and see how they reason through things, how they step through, how they decide. That's going to give you more in the ability to serve your clients in the future than virtually anything else you can do at a law school. So I strongly encourage you to consider clerking. It's not just, oh, hey, I've got a year to decide what I want to do. It's really valuable in terms of your ability to serve your clients with respect to whatever field of law you go into.
Well, and I'll say a couple things. If you clerk for a judge, that judge will always be your cheerleader like the rest of your career. And secondly, if you're ever thinking about getting married, it's a really cheap way to have an officiant.
We have some law clerks here, so if you can find them, talk to them about the process and how much they like it.
My law clerk, who is an SMU grad, is right back there.
Mine's on the back row.
I mean, maybe our clerks should actually stand up so that we can see.
Clerks. He's my
Bailey, stand up.
research attorney. You can talk to him about a clerkship.
Yeah, like
Mine is here.
yeah, like the whole back, like exactly. Like if we're asking you to go talk to them, then how about the clerks from our court that have made it here? Could you please stand up so that they know what you look like, so they can possibly seek you out at lunch?
Excellent.
Thank you, and thank you for your hard work.
Okay, is there another question? One more? Going once, going twice? Okay, we're going to go back and decide this case now, and then we're going to have lunch. Thank you very much for having me.
Stay tuned for whether Woodard survives.
Awesome. You did awesome. You did great. You did great.
And are they, I would like it different. I feel they were justice.
I'll leave it with Dan.